Welcome back to the BZ Watchdog News Network. Before we get started, smash that like button, drop a comment, and share this everywhere if you want to see more illegal meetings get shut down by me, BZ Watchdog. Because today, Hill County gave us another beautiful example of what happens when public officials think the words executive session are some kind of magic spell that makes the law disappear. I could not make it in person to Commissioner's Court today, so I appeared by Zoom. But several citizens did show up in person, and they were there for one reason: to put eyes on this vague, shady executive session about pending litigation. Pending litigation about what? Who knows? The agenda sure did not tell the public, but let's be honest, based on everything going on, this sure looks like it was connected to the data center mess, the moratorium, and whatever backroom panic is taking place after the people started waking up and asking questions. And that is exactly the problem. Under the Texas Open Meetings Act, you do not get to hide behind vague legal buzzwords. You do not get to simply write pending litigation and then disappear behind closed doors while the public is left guessing what county business is being discussed. The people have a right to know the subject. The people have a right to meaningful notice, and the Texas Supreme Court has already made clear the government bodies cannot use vague agenda language to keep the public in the dark. So I used the law against them. I put them on notice. I gave them the case law. I explained that a vague executive session notice does not magically become legal just because somebody in the courthouse wants it to be legal. And then here comes the county attorney, David Holmes, citing a 2024 Attorney General opinion and recommending they not go forward with that executive session. Now, I'll give him credit where credit is due. He did the right thing in that moment. He saw the problem. He knew the notice was weak. He knew the legal risk was real, and he recommended they not walk themselves into a Texas Open Meetings Act violation right there in front of everybody. So no, I didn't have to show him up. He basically confirmed what I was already saying. But let's not miss the bigger picture here. Why does it always take citizens showing up, recording, objecting, quoting the law, and putting elected officials on notice before these people suddenly remember that Texas law applies to them? Why does the public have to babysit Commissioner's Court just to keep them from sneaking into closed session over vague agenda language? Why are we constantly seeing this pattern around data centers, land deals, moratoriums, tax abatements, utility capacity, and economic development conversations? Because sunlight is the best disinfectant, and some of these people appear absolutely terrified of sunlight. This is what happens when government forgets who it works for. They do not work for developers. They do not work for data center companies. They do not work for consultant, lobbyists, attorneys, or whoever is whispering in their ears behind the scene. They work for you, the people of Hill County. And when the agenda does not tell the people what is really being discussed, that is not transparency. That is not accountability. That is government by guessing game. And today, that guessing game got shut down. Not because they wanted transparency, not because they suddenly felt generous, but because the law was put directly in front of them, on the record, with witnesses watching. That is why you record meetings. That is why you read the agendas. That is why you challenge vague executive sessions. That is why you do not let public officials hide public business behind closed doors. So to Hill County, the people are watching. To the commissioners, vague agenda language is not a loophole. To anyone trying to push these data center deals in the dark, the lights are coming on. And to everyone watching this video, this is how you fight back. You show up, you record, you read the law, you put them on notice, and when they try to walk into an illegal meeting, you stop them before they get there. If you want to see more illegal meetings get exposed, more backroom deals dragged into the sunlight, and more public officials reminded that they are not above the law, go ahead and smash that like button, drop me a comment, subscribe, and share this everywhere, because BZ Watchdog is not going anywhere. And as always, sunlight is still and will always be the best disinfectant. And today, Hill County got a full dose.
BZ Watchdog News Network.
To agendas, I understand that takes time, but time is of the essence. There's a reason why these companies are already upset that you guys put this out there because they know, and they're trying to sneak stuff in before January so that they won't have to be grandfathered in, which is scary. That's really scary. So a couple of these counties you've heard of doing this, right, are Van Zant and Gillespie counties. Van Zant legally paused BEST projects because they evaluated local fire, health, and explosion safety requirements. Companies were required to get thermal runaway testing, which failed. Because of this failure and violation of the fire code, they were granted a restraining order against all companies in the process of building BEST storage facilities in the county until they can guarantee their safety. Gillespie County, court ordered temporary injunctions blocking BEST construction because of dangers of thermal runaway, toxic gas, and the local volunteer fire department's inability to extinguish lithium-ion fires. Let's see. So as the authority having jurisdiction, the court is also currently responsible for the commissioning and decommissioning of every single battery energy storage system. That's you guys. You oversee to make sure that's done correctly. And I'm asking you, do any of you guys prepared to do that?
Good morning, gentlemen. Linda Polly here with the Save Hill County Group and the Texas Coalition Against Data Centers. The first thing I'm going to address is I understand that there was email sent regarding a formal complaint regarding potential violations of the Texas Open Meetings Act by the Hill County Commissioners Court agenda. Today's date, May 26, 2026, item number 14. I'm submitting this formal complaint concerning a potentially deficient meeting notice posted by Hill County Commissioners Court under the Texas Open Meetings Act, Chapter 551 of the Texas Government Code. The posted agenda language states, pursuant to the Section 551.071 of the Texas Government Code, the Hill County Commissioners Court will meet in a closed executive session to consult with attorney regarding pending or contemplated litigation. This notice appears legally insufficient under Texas Government Code 551.041 because it fails to adequately identify the subject matter to be discussed in executive session and therefore does not provide meaningful notice to the public. The notice does not identify the litigation or dispute involved, the parties involved, the governmental action or policy at issue, the property, contract, project, or regulatory matter involved, or any factual description sufficient to inform citizens of the governmental business under consideration. Texas courts have repeatedly held that governmental bodies must provide sufficient specific to alert the public to the topics that will be discussed. In Cox Enterprises, Inc. versus Board of Trustees of Austin Independent School District, the Texas Supreme Court emphasized that the purpose of the TOMA is to ensure that the public is informed concerning governmental decision making and that notice must not be so vague as to deprive citizens of meaningful awareness of public business. The court recognized that merely providing broad or generic descriptions undermines the purpose of the act. Similarly, in Acker versus Texas Water Commission, the Texas Supreme Court held that the Open Meetings Act requires notice that is sufficiently specific to disclose the subjects to be considered so that members of the public may intelligently decide whether to attend or monitor governmental proceedings. Here, the Hill County Commissioners Court appears to have provided only a generalized statutory citation and conclusive statement regarding pending or contemplated litigation without any meaningful identification of the actual governmental matter involved. While Texas Government Code 551.071 prevents confidential consultation with legal counsel under certain circumstances, that exception does not eliminate the governmental body's independent duty under 551.041 to provide adequate notice of subject matter of the meeting. As written, the notice prevents the public from determining whether the executive session concerns litigation involving taxpayer funds, floodplain or developmental matters, zoning or land use disputes, county contracts, regulatory enforcement, personal matters, or the issues of significant public concern. Accordingly, we respectfully request an investigation into whether the posted notice complies with the Texas Government Code 551.041 and 551.071. A determination regarding whether the executive session exception is being applied in an overly broad or improper manner, preservation of all records related to the meeting, including agendas, certified agendas, recordings, emails, text messages, draft postings, and attorney communications to the extent required by law. Any corrective action authorized under the Texas Open Meetings Act, including reposting of agenda items, reconsideration of actions taken, or any other available remedies. Please also consider this correspondence a formal request for preservation of evidence and public records related to this matter. Thank you for your attention to these concerns and for your commitment to governmental transparency and compliance with Texas law.
Gary Johnson, Bynum, Texas. I brought up some concerns last week, and by the way, thank you, sir, for being the one to stand up and start the whole, good news on that last meeting I attended. And thank you, sir, for finishing it off. However, everybody's bringing up some good points about all these data centers, just industrial projects. Now, I'm not against growth. I am a business owner. I'm for growth. Obviously, we want to grow. I know how money works. However, the issue is the lack of responsibility from this court. It's been seen through the Hubbard Wind 2 project. There was, again, I brought it up last time I was here to you, Shane, that you told me in January if there was a tax abatement in place that you would do something. And after weeks of coming to this lady here, trying to find the tax abatement, nobody knew about it. Nobody knew where it was and how to find it, circling loops to get it. I don't know with all the technology we have today, how that happened. After a couple of weeks of trying to track it down, I did track it down and I myself read it. And there's a lot of things that were put in place to protect the citizens of Hill County. And those things are not taking action on. There's no action taken when citizens bring up road damages, not just like minor road damages, structural failing road, infrastructure failure. The tax abatement clearly says all damages are presumed to be caused by the companies unless proven otherwise. I've given you guys evidence. I've given you guys verbal evidence, photo evidence. I've submitted videos via email. I've asked a lot of questions. One in particular is, why wasn't the pre-construction road survey that was mandatory per the tax abatement for Hubbard Wind 2 in your hands? You guys have a responsibility. If you don't have that pre-construction survey, how can you hold accountability where it needs to be held, right? Now, I say this because it doesn't make sense. I mean, I'm not in your shoes, but I could say if I was a commissioner and I cared about Hill County citizen safety, especially road safety that we have to travel every day, knowing there's a blown out culvert in the road, it's broken underneath the road. I've sent pictures. You sent your attorney / road engineer out to take a look at it. They brought no inspection tools. They brought not even a tape measure. They took a couple pictures with cell phone. It's in a pipe. They could have got down, went like that, looked up at it. They didn't even do that. They just acted like I was crazy. Doesn't make sense. When concerned citizens bring up infrastructure failure that they've seen and they have proof of, nothing's done. Then you send the city crew out to fix it. The tax abatement clearly says that written notice has to be given to the company. When I asked David Holmes what he was going to do, he said, I talked to him. His signature's on that tax abatement. He knows. Written notice has to be given. Has the written notice been given for all the concerns that have been brought up? They're not accountable if the written notice isn't given. This is the concern I have with any kind of growth moving forward. Where's the accountability? Where is you have authority to take action. And I know you sent me personally back when I've asked you questions that you personally don't have authority. But this court has to act as a well-oiled machine as a whole. That's what works. It doesn't work when one of you work and the other one's not. I mean, we need all of you together as a team to work. I mean, united we stand, divided we fall. Come on, I mean, if we don't unite together to make a better world, it doesn't happen, right? It's common sense. Let's bring common sense back. I mean, it doesn't take rocket science to fix the issues that we've represented to you guys. It's easy. We could have written notice. They had 30 days to fix things. But no, you sent city road crews out, Hill County road crews out to fix the damaged culvert that still hasn't been fixed. but they came out to assess it and said they're gonna come back and fix it. Why are our tax dollars being used for something that can be put back on the companies who damaged it? Why is that falling on a taxpayer? It's avoidable. So I ask this, how can we take on any kind of big industrial projects, especially the numbers that are coming in, when we can't even handle what's going on now? How can Hill County citizens trust you guys? There's something bigger. That's all I got.
Thank you, sir. Thank you.
Good morning, Judge Basil and Commissioners. My name is Basil Zangare. I go by BZ Watchdog on Facebook and YouTube. And I'm here today to put this court on notice, on the record, and in front of the people of Hill County. First, let's talk about the Texas Public Information Act. For approximately 60 days, Martin Lake, Scotty Hawkins, and others using county email systems have failed to properly fulfill my lawful public records request. These were not optional requests. These were not personal favors. These requests were made under the Texas Public Information Act, Chapter 552 of the Texas Government Code. The law requires prompt production of public information. It does not allow county officials to ignore, stall, delay, or hide records just because the records may be politically embarrassing, inconvenient, or connected to controversial county business. If county officials are conducting public business on county email, those communications are public records unless a lawful exception applies. And if an exception is claimed, the county is required to follow the statutory process, including timely action. Sitting on records for 60 days is not transparency. It is obstruction by delay. Now let's move to what this court appears ready to do today under Agenda Item 14. Your agenda says, pursuant to Section 551.071 of the Texas Government Code, the Hill County Commissioners Court will meet in a closed/executive session to consult with an attorney regarding pending or contemplated litigation. That is not enough. The public has no idea what litigation you're talking about. The public has no idea what public money, public policy, public land, public contracts, public controversy, data center issue, development project, settlement discussion, or county deal may be discussed behind closed doors. That agenda language is very vague, generic, and legally dangerous. The Texas Open Meetings Act is not a magic curtain you can hide behind by simply saying pending or contemplated litigation. Section 551.071 allows attorney consultation in limited circumstances, but it does not erase the public's right to meaningful notice of the subject being discussed. The Texas Supreme Court made that clear in Cox Enterprises Incorporated versus Board of Trustees of Austin ISD, where the court held that vague executive session notices using broad labels like litigation were inadequate when they failed to give the public reasonable notice of the actual subject matter being discussed. The law requires more than buzzwords. The Texas Government Code Section 551.041 requires written notice of the date, hour, place, and subject of each meeting. The entire purpose of that requirement is so the public knows what its government is doing before the meeting happens, not after the decisions are already made behind closed doors. So let's be clear. You cannot simply post litigation and then disappear into a back room to discuss whatever deal, lawsuit, threat, data center matter, developer dispute, county contract, infrastructure issue, public funds, road issue, water issue, electrical capacity issue, or political problem you want hidden from the people. If you are discussing litigation, identify the litigation with enough detail to give the public meaningful notice without compromising privileged legal strategy. If this involves data centers, say that. If this involves a developer, say that too. If this involves a settlement, say that as well. If this involves public money, infrastructure, county roads, water, electrical capacity, land, abatements, incentives, or economic development agreements, the public deserves to know the general subject. Hill County does not belong to the Commissioner's Court. Hill County belongs to the people. The people are tired of vague agendas, hidden discussions, delayed records, and public officials acting like transparency is optional. The law does not exist for your convenience. It exists to protect the public exactly from this kind of secret government. It exists to protect the public from exactly this kind of secret government. And if you proceed into closed session today under this vague agenda item, I'm putting every member of this court on notice. I'm prepared to file complaints regarding every official who motions, seconds, votes, or participates in an unlawful closed session. I will request the certified agenda. I will request the recording if applicable. I'll request all related communications. I will file complaints with the Texas Attorney General. I will pursue criminal complaints under the Texas Open Meetings Act where applicable. And I will document for the public exactly who participated in this. So before you go into executive session today, I'm asking you to stop. Consult your county attorney in open session about whether this agenda item is legally sufficient, and do not proceed under a vague, pending, or contemplated litigation. Label that fails to tell the public what you are really discussing. Because if you do proceed, then the record will show that you were warned before you did it. And let me be very clear. If this court knowingly continues forward with an unlawful closed session after being placed on notice that the agenda item is vague and legally defective, I am prepared to file criminal complaints against the officials involved. That includes complaints for abuse of official capacity under Texas Penal Code Section 39.02. If public office, public resources, or government authority are used to obtain a benefit, harm another, misuse public funds, or conceal public business unlawfully. It also includes complaints for official oppression under Texas Penal Code 39.03 if public officials acting under color of law of office. It also includes complaints of official oppression under Texas Penal Code 39.03 if public officials acting under color of office intentionally deny or impede citizens in the exercise of their rights, including the public's lawful right to access government information and attend properly noticed open meetings. The people of Hill County have a right to know what their government is doing. You do not get to hide behind vague agenda language, delay records for 60 days, and then walk into a closed room as if the Texas Open Meetings Act and the Texas Public Information Act do not apply to you. If you continue, I will pursue complaints against every official who motions, seconds, votes, or participates in this unlawful closed session. Thank you.
All right, next thing we're doing is number 14. If you have any input on that, pursuant to the concerns that were discussed in the open forum.
There is a 2024 AG of Community 0475 that says boilerplate language in the notice is not sufficient, so y'all folks going today, that's fine.
Say that again.
There is an AG opinion in 2024 KP 0475 that says boilerplate language of an executive session is not sufficient, so if y'all don't feel comfortable going forward. I mean, I don't think what I plan to discuss is super time sensitive. There are actually a few matters that I can bring up, but
Table that. All right, then we'll table item 14. That leaves the last one. Make the motion to adjourn. They are done.
Is the best disinfectant. Sunlight. Easy Watchdog.
Tyranny, corruption, extortion. Sunlight is the best disinfectant.
BZ Watchdog News Network.
BZ Watchdog.